Back on the record in Giles versus Justice. Counsel, did you have an opportunity to read the Donna's House Central letter dated November 10th? And I can tell you it just came in at 9 o'clock this morning for the court. Okay, very good. I know that you have subpoenaed her. Is there any objection to Ms. Parlin testifying?
Well,
yes or no?
no.
Okay, bring her in.
Okay. Yes.
Can you please raise your right hand? Did you solemnly swear the testimony you're about to give in this action should be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated.
Good morning. Could you please state your name and your occupation?
I'm sorry?
Could you please state your name and your occupation?
Yes. My name is Jan Parlin. I'm the program manager for Donna's House.
Thank you, Ms. Parlin. And you were subpoenaed here today?
I'm sorry?
You were subpoenaed here today?
Yes.
Okay, very good. All right, and who, you subpoenaed her, Mr. Anderson?
We did.
All right, thank you very much. Go ahead.
Could you tell me what your job duties are as program manager?
I'm sorry. I'm having trouble hearing you.
That's fine. What are the duties of a program manager such as yourself at Donna's House?
I manage the program. I do all the scheduling. I do most of the orientations. I do the reports for the court.
And how long have you been employed in that capacity?
I've been in that capacity. I've been there since March. I've been with Donna's House 5.5 years.
I didn't hear that. March?
In March you became the program manager?
I became the program manager in March.
Yeah, but you've been with Donna's House for 5.5 years.
Mm-hmm.
Yes? Yes? You have to answer verbally.
I'm sorry, what?
You need to answer it with words.
Mm-hmm.
Do you need assistance of the headset?
I'm sorry, what?
Frank, headset.
Trouble. Yeah.
Does that help you hear better?
Yes.
Okay. So, prior to being the program managers at Donna's House, what was your position?
I was the visitation supervisor.
Yeah, you mentioned as among your duties are doing most of the orientations.
Mm-hmm.
What do the orientations involve?
They involve going over the rules of the program, how the program runs, what the time spans are that each party should show up, if there's any fees assessed, discussing with the parties.
Yeah, I presume that the orientation process is designed to serve a purpose.
Yes.
And what purpose does the orientation serve?
To eliminate constant questioning, so that people are familiar with what you expect.
And during the orientation process, you tell us you go over the rules.
Mm-hmm.
What are the rules that you go over during the orientation process?
Several pages of rules, but the primary ones are that the parties need to complete the orientation within 30 days, that the that we stagger it so that the visiting party comes 15 minutes ahead of time. The custodial parent comes 5 minutes of the hour. That way they don't run into each other.
Is there a particular reason you don't want that to happen?
Drama. We have people who cannot be near each other. Some people are civil, some people are not. We also, we discuss that children under 3 can have snacks, older children cannot. That if it's a birthday or holidays, toys can be brought up. Otherwise, they can be left at security, and then they're given to the custodial parent and their choice what to do with them. Children over 3 can just have water. Either parent can provide the water, or there's a water fountain. There's an overpriced machine where you can buy water.
Is a parent allowed to bring gifts and candy to the visits?
As I said, children under 3 can have snacks, over 3, no. They can leave the items at security, and they'd be given to the custodial parent on the way out.
Yeah, I suppose there's a purpose that rule serves as well.
Yeah, because we don't really own the Donna's House space. We kind of rent it, so to speak, from family mediation, and they really don't want ground-in Cheetos on their rug, that sort of thing.
What about, is there any rules against a parent bringing pictures or mementos to give the child?
If there is no objection from the other parent, we have no objection. It has to be consensual.
So, are you telling us it has to be cleared with the other parent before the non-custodial parent would present a picture or a gift?
Correct.
And
I mean, we have parents that bring in albums of family members, and it's okay. But, you know, some people it isn't okay.
but your rules require it to be cleared with the other parent.
Correct.
And I presume there's a purpose behind that as well.
Yeah, because we don't know all the dynamics, and there may be some issues.
Do you expect your parents participating in the program to follow the rules?
Yes.
Now, during your familiarity with this particular case and the visitation that occurred at Donna's house, have there been some problems concerning the mother, Miss Justice, following the rules?
The problem is that we document what we observe. No rule violations were observed. Rule violations were reported to us by Mr. Giles. We did speak with Ms. Justice about bringing gifts and food, and she said that she would not do it again. Other than that, we actually never saw any violations of rules. They were alleged to us in some detail by Mr. Giles, but my staff did not notate any actual visual.
Did Mr. Giles express concern to you about
Yes.
what the mother was doing?
Yes.
Now, you said that you brought up the gifts and candies with Miss Justice, and she said she would not do it again.
Correct. I took that as meaning that she
Acknowledged she had
that
broken rules.
acknowledged that she had done it. But I was told by staff that they were asked about the picture, and it was not slipped into the child's pocket, which it was alleged. I do not know.
Well, do you know whether she cleared it with the father before she gave the picture to the
I
child?
do not know. That was never made clear to me. I mean, Mr. Giles says it was not made clear to me by staff.
What is the extent of the observation that your staff does during these visits?
They watch the visit. If they should overhear anything inappropriate being said, false promises, inappropriate questioning, whispering, that sort of thing, they will intercede. If they don't see it, they just observe on what takes place during the visit. And all the observations that we had were good, that, mother and child got along well, that they played various games, and those sorts of things were observed.
From what type of distance would these observations occur?
Okay, probably, for the most part, I would say maybe as far as where I'm sitting to where you are at that table, for the most part. There may be some that were closer, but
And does
maybe a little closer.
Does each visit have one observer assigned to it?
Well, they're not one-on-one observations. So we have several families at a time, but we have anywhere from 4 to 6 staff people on at a time. So each staff person is assigned which families they're going to be watching.
And does that staff member get assigned more than one family to watch?
Sometimes depending on the number of families that we have present.
And there was, you mentioned one of your duties is to write reports, and you've written a report to the court.
Correct.
Looks like you're busy on Saturday writing that report.
Well, once we had the word from Mr. Giles that he was, I had started the report prior to that, and once he said that he wasn't going to be continuing with Donna's house, at that point I finished it up and got it out.
And in your report, you noted that there were some time changes requested by the mother.
Yes.
In November. The father agreed to those?
Yes.
Do you know what the reason was for
No, I do
the
not.
requested time change?
I do not. She said that there was 2 or 3 visits that she requested it for. I think 2.
If the mother were to have put a patch on the child's clothing in the back of his shirt, would that be consistent with the rules of the program?
Objection lacks foundation.
We'll be able to.
It's a hypothetical. So yes, it would lack foundation, I agree.
I'd ask that we just have our answer subject to laying the foundation without occurring.
Yeah, it's a hypothetical. Go ahead.
It would not be, we have parents and children that play with stickers frequently. It is not against the rules.
Is there, getting back to the mother's request to change the time, is there a certain time period that the parent has to make to request the time change?
We generally state that once you have a day and time, that's your day and time, but the reality is there are times when people need to make a change. And if the other parent, the custodial parent, is willing to, we'll ask, and if they're willing, as long as there's sufficient time for us to ask the other parent, get a response, update our schedule, update security's schedule, we'll try to accommodate that. We can't always do it.
Is there a 14-day notice at any point posed for changing the schedule?
No, the 14-day notice is for vacation time periods. We ask for, if possible. We do have people that have parenting plans that delineate vacation times, and we ask for that.
Now, there was a report on the most most recent visit on Friday is to someone not following the staggered time rule, is that correct?
Objection
Correct.
on leading.
Sustained.
Did any concerns come up Friday with concern to the visit on Friday?
Yes, the problem was, well, there were several problems. One, we have little to no control of what happens in the parking lot. Second of all, staff state that Mr. Giles and Mr. Terrell were
Objection here,
quite a
Your Honor.
distance away from each other.
Sustained.
Mr. Giles states that they were no more than 2 rows away from each other. He states that Mr. Terrell made threatening hand gestures. I don't know. It was very dark. I don't even know if he could have seen hand gestures if he was at that distance. If he was this distance, probably could have. Nobody
weren't-
seems to agree on where anybody was parked.
Sustained.
Well, you weren't present in the parking lot.
No.
You don't know what the lighting was like at that time.
No, but it was dark. We know that
And
at this time of year.
the concerns that Mr. Giles related about someone not following the time staggered rules, does that raise concerns about participation in the program?
Yeah, I mean, that is something that we will definitely speak with people about. It certainly wouldn't be the first time somebody has done it for whatever reason, deliberately or inadvertently, where one party has come early and one party has come late to run into each other. Ms. Justice says that she asked the other party, Mr. Terrell, to park a distance away. Staff did suggest to her that he should come later. Mr. Giles said he felt threatened. I mean, security walked him to his car. I don't know for how long security keeps their tapes of what takes place in the parking lot and or how extensive they are. That's something you would have to take up with security.
Should incidents like those alleged on Friday occur if the rules are followed?
If it should not, no.
And I think you noted in your report that Mr. Giles indicated he no longer wished to utilize Donna House services?
Correct.
When did he do that?
Friday. Well, actually, I think it was Saturday when I spoke with you. Yeah.
And you proceeded to close the case?
Yeah.
If the court felt supervised visitation was still in order after our trial today, could Donna's house reopen?
Absolutely. Absolutely. There's not.
Nothing further.
Cross.
Yes, Your Honor. Good morning, ma'am. Have you ever testified in court before?
Yes.
Approximately how many times?
I have testified once here in family court, and when I lived in Florida, in my position there, I testified frequently.
Okay, and just briefly, when you testified the one time here in Nevada, was that at the request of a subpoena from the lawyer, or was that sua sponte from the court?
It was a
It was
request
in
from the
this
court.
courtroom,
Yeah.
and it
Oh,
was
really?
Yeah.
by me.
Yeah.
Oh, okay, so you've never been subpoenaed before?
I have been subpoenaed, but just to submit documentation, not to physically appear.
Okay, what did you review in preparation for your testimony here today?
I looked at the file, I had, as I said, I recently wrote the report, and I just reviewed the supervision notes from the staff, and there were no concerns listed on those.
And Your Honor, at this time, considering she reviewed other materials in preparation for her testimony under NRS 50.125 and Sands v. 8th Judicial District Court 130 Advanced against opinion 13. We would like the opportunity to review her entire file as it's materials that are being relied on by her and to refresh her memory in anticipation of her testimony here today. I can continue to question her, but would make that objection that she's testifying based on things we've never even seen.
I believe she testified that she reviewed staff notes.
Mhm.
She'll make those available to you.
Okay. I'm not sure how.
I
the
wasn't
court-
sure if I was allowed to.
Well, I'm not sure how the court may handle that, considering today was the day for trial, but we would note that. Obviously, we would like the opportunity to review those materials.
And maybe she has them here for council to review.
I do?
But we're gonna continue because Mr. Anderson didn't have them either, so we're gonna continue. Go ahead.
And we obviously reserve the right to seek any and all remedies under that statute, Your Honor.
You can review them after she testifies because we're taking you out of order, so to speak.
Mhm.
They haven't even given their opening statements yet,
Oh.
but I realize that you have a program to run, so I wasn't going to hold you up and have you sit
Thank
out
you.
in the hallway. So when you're through testifying today, if you could, get your staff notes, and during the break, council can come down and look at those.
Okay, I've got them with me. Will counsel come to my office, or how are we doing it?
Yes,
Yeah,
because we need
okay.
to continue with the
Okay.
trial.
That's fine.
So you may be subject to being recalled,
Okay.
okay?
Mhm.
Thank you.
Okay, thank you, Your Honor. Prior to the hearing today, have you ever spoken to Mr. Anderson, the counsel to the state?
No.
Okay. You noted in your report here that that no concerns were noted by the staff
No?
during the visitation. You testified about that, correct?
Correct?
And the observations involved my client playing with the child, playing ball, playing with the kitchen set, remote control cars, etc., correct?
Mhm.
Now, there was this note about, in your report here, about my client supposedly giving the child candy right before Halloween, correct?
Mhm.
That's a yes?
Yes.
Okay. And you testified that a staff member sits in front of the parents and the child while they interact, correct?
Mhm.
And are you aware that the staff member apparently saw my client trying to give the child candy?
There was no documentation of that.
Okay, but that's possible that the staff member observed that and permitted it to happen.
Objection is to possible, also speculation.
It is, calls for a speculation, just as some of your questions did about the stickers, so I'm gonna allow it.
Okay. There was you testified in your report reflects that the father, James, had contacted you to discuss his concerns, correct?
Yes.
So whenever he called in concerns, was it always to you?
Yes.
Okay. And approximately how many times during the 9 visits here did he call in concerns to you?
I'm not sure if it was 2 or 3.
Okay. And my client never voiced any concerns, correct?
No.
And this incident, this alleged incident about the child giving a note, you testified in your report reflects that the father,
Excuse me, when you say note, do you mean the picture?
the picture, I'm sorry.
Okay, I'm sorry,
the
yeah,
picture.
okay.
So the picture, your report reflects that James called in and said affirmatively that the picture was slipped into the child's pocket, correct?
Correct.
He affirmatively stated that.
Yes.
Okay. However, when you talked to your staff, you came to the conclusion that actually my client asked permission to give the picture, and they informed her that it was up to the custodial parent to be accepted, but it was not slipped into the child's pocket, correct?
Correct.
So Mr. Giles' comment about, or allegation, that the picture was slipped into the child's pocket is not true, correct?
It does not appear to be, no.
Well,
I've not.
appear to be.
I know, I mean, I'm,
Hold on, ma'am,
Mhm.
respectfully, it's not appear to be. Your report says that it was not slipped into the pocket, correct?
correct.
Okay, so his allegation that it was is not true, correct?
Yes.
Objection, argumentative.
Sustained.
Cross-examination, Your Honor.
I understand it's cross-examination. Also, this witness has no personal knowledge, and the court understands that in the report. She's not
Okay.
testifying from personal knowledge at all.
Okay, but, I'll rephrase, so, your staff informed you, though, that his allegation was not true, correct?
Correct.
There's also a note that you were contacted by, in your report, that you were, contacted by James, that my client was allegedly saying inappropriate things during the visits. However, your staff heard none of those statements, correct?
Correct.
And your report states that it's unknown if Felicia was whispering to Dean or if the statements are untrue, correct?
Sure.
Okay, and you testified when Mr. Anderson was questioning you that if a parent is whispering to a child, if the person supervising the visitation will get involved and not permit that to happen, correct?
Correct. But there are people who have done it sneakily.
Okay, but there's no evidence that you have, and your report does not reflect that my client whispers to the child at all.
No?
So, if she didn't whisper to the child, that, in your report, indicates that also possibly the statements made by Mr. Giles are not true, correct?
Possibly.
Okay. We'll talk about this alleged incident on Friday. Are you aware of there being cameras outside of the family court videos, or the family court house here that captures things on video?
I believe that there is, and I'm not 100% sure, but I believe that there are some cameras that cover the security area and possibly the parking lot.
Okay.
But they do not have anything to do with Donna's house.
Okay, but you're aware that sometimes the courts order people to exchange children at the family courthouse
Mm-hmm.
because there's police present, there's cameras present, correct?
Correct.
Okay. And during this alleged incident on November 9, did you speak to Mr. Giles that day?
No, I spoke to him the following day.
Okay. So, did he notify anyone, to your knowledge, did Mr. Giles notify anyone at Donna's house of this alleged incident on the day it happened?
Yes.
Who did he notify?
I know he notified Yolanda Fernandez. I don't know if he notified any other staff. But I know that he was expressing concern.
Oh, hold on, I'm going to slow you down.
Okay.
Who did he notify that day?
A staff person named Yolanda Fernandez.
Yolanda Fernandez. And what's her position?
She's the visitation supervisor. And he asked security to walk into his car.
Now, was that when he was coming to pick the child up, or when, at what point, to
Yes,
your knowledge, did he
Yes,
supposedly have this interaction?
when he was picking the child up at the end of the visit.
And there was no allegation that any person got out of, my client's boyfriend did not get out of the vehicle,
No,
correct? Did he indicate, or do you have any knowledge indicating how he knew that was my client's boyfriend's vehicle?
I don't know.
Okay. And you indicated that in your report, that the car was parked basically across the parking lot, correct?
That's what staff said.
Okay.
Mr. Giles said
And there was,
otherwise.
you testified that obviously due to the timing, it was dark out, correct?
Mm-hmm.
That's a yes?
Yes,
Okay, what time approximately was this alleged incident?
almost 8 o'clock.
Okay. And testified today that the boyfriend was allegedly making, or Mr. Giles indicated that there were, quote, threatening gestures, but in your report, you note that it states, he stated the boyfriend, quote, flipped him off.
I was trying to be polite here in court.
Okay.
And it's a threatening gesture.
So it wasn't threatening
Okay.
gesture, correct?
Obscene gesture? I don't know.
Well, I want to be very clear what your
Okay.
testimony is.
Mr. Giles used the words flipping me off.
Okay, so he didn't say there were threatening gestures.
No.
Okay. And you even testified today that you don't understand how maybe he could have even seen that, considering.
Correct.
the-
That's a supposition. I don't.
Okay. And as far as visitation at Donna's house, that was canceled by Mr. Giles after, or when you spoke to him on Friday.
Saturday.
I'm sorry, Saturday, correct?
Yes.
So, the effect of that was that my client was unable to have visitation with the child on Saturday evening, correct?
Correct.
Okay. So, the party, is it your testimony that a party can unilaterally cancel visitation on their own?
Yes.
Okay, even if it's totally unfounded, so to speak?
One or both parties can request case closure, and we will accommodate that, but as I always say to people, and I believe I said this to Ms. Justice on the phone, it's always up to the court. The court may reopen it.
Okay. And Mr. Giles didn't say, I want to use another place for visitation, correct?
He did not.
He just said, I want to cancel off his future visitation.
Objection.
At
Ms.
Jonna's
Stacy's
house.
testimony.
At Jonna's house, he said, yes.
Okay.
Because he didn't feel
What is
safe.
your objection, counsel?
Ms. States, her prior testimony.
She answered it, Your Honor. As
It's
far-
sustained, her testimony is what it is, thank you.
Now, besides these specific allegations in your report, well, also I would say, Your Honor, I would move to admit the Donna's House report into evidence.
No objection, I think it is part of the record.
Okay, it will be admitted, what will it be designated, please?
You want to make it the court's exhibit?
Is that what counsel wish?
I would have it marked as Defendant's Exhibit 1.
No
No, you
objection.
can't, you have to use letters.
I'm sorry, A.
Exhibit A?
Yeah.
I don't think it matters what it comes in as, so no objection.
Thank you.
So besides these specific allegations that Mr. Giles made, what were some of, to your knowledge, what were some of the other comments that he voiced to you when he would call into you?
He just felt that Ms. Justice was not following rules. He repeated that a number of times. He felt that she wasn't following the rule, and he was concerned.
Okay. And in your opinion, well, strike that out. Obviously, according to your report, some of his concerns were obviously not correct. Is that true?
They do not appear to be founded, no.
Okay.
I didn't hear that answer. They
Oh,
did not
Rena.
appear
To be founded.
to be founded. Thank you.
It's indulgent. Isn't it true that staff members also follow people into the bathroom with
Correct.
the children? Correct. So there is very tight supervision at these interactions, correct? With the parent and child?
It's fairly, yeah. I mean, it's more, if it's an older child that is very independent with toileting, there is going to be less supervision than there is with a younger child. Maybe a child in diapers or whatever. But the staff is present, yes.
And as far as this notice and changing times, your report reflects that the parties actually agreed to the requested time change.
Yes, Mr. Giles was fine with that.
So there was no, it wasn't like my client was trying to force change
No.
time, correct?
No, she requested it, I asked him, he said okay, and we went from there.
And she gave at least a 1 week notice, correct?
I believe so, yeah.
Okay. And just again for the record, during the entire 9 visits that happened at the Donna's house, there were no concerns noted by your staff or yourself regarding the actions of my client, correct?
Correct.
No further questions. But we would reserve the right to recall her subject to.
That's been put on the
review.
record already.
Yes, Your Honor.
Thank you, counsel.
So, you testified that Mr. Giles expressed concern with Ms. Justice not following the rules.
Correct.
Did he indicate to you that she had not followed this court's order concerning the custody of the child?
Objection irrelevant, Your Honor.
Is that,
Relevant,
can you specify
Yeah,
this
I'm not
court's
sure what you
orders or
mean.
rules?
Yeah.
I'm not sure what you mean.
I can try to rephrase the question.
Thank you.
When he expressed concern over her not following the rules, he explained to you that she had not followed this court's order from June 27th as far as custody of the child.
He stated that she had withheld the child from him, yes. That's what they're referring to.
You know, you could say that staff will go into the bathroom to kind of monitor things. A staff is responsible for more than one family, and they follow a child into the bathroom. Does that leave the other family that they might be responsible for uncovered?
Objection, Your Honor. Calls for speculation and presumes facts not enough evidence.
Calling for their
Overruled.
procedures.
Actually, there is a
According to your
policy.
procedure, right.
Okay, there is a
Overruled.
policy around that, which is that if you need to take your, one of your families to the restroom, you ask somebody else to cover it, you know, for that 5-10 minute period, you ask somebody else to cover it and let you know if anything of significance takes place.
And as far as what may have occurred in the parking lot, are you familiar with this parking lot?
Yeah.
Do you know that there are lights in it at nighttime? Yes?
Yes.
And on that occasion, was Mr. Giles compliant with the stage times called for under the rules?
I believe so. Again, I was not. It does sound like, from what I was told, it does sound
Objection,
like
Your Honor. Here's
Mr.
objection.
Terrell was a few minutes early. I mean, a few minutes early. And he should have been a few minutes later in picking up Miss Justice.
From your investigation, do you know how early Mr. Terrell was?
I'm not certain.
Now,
Nobody actually saw him pull up, so I don't know.
the fact that a statement might not be heard by staff, does that mean to you that a statement wasn't made?
No. So, picture and time, that's all. That's all we can report.
When we look in your report about the picture, you state that it was not slipped into his pocket, and you put the word slipped into in quotes.
Correct, because those were the terms Mr. Giles used.
So in doing so, does that exclude that it could have been placed in his pocket, but not slipped into his pocket?
I suppose staff did say that there was discussion with Miss Justice, and she was told that, you know, that the dad would need to approve it, but they were aware that there was a picture.
Is staff directed to enforce the rules?
Yes.
Did they have any leeway in determining how they're going to enforce the rules?
Sure. There are circumstances that don't fit exactly, you know, but yes, staff have leeway. They also can terminate visits if necessary.
so that they have discretion not to enforce a rule if they consider it a minor violation or?
No, not really, but they would, but the level of punishment might vary. If we have a circumstance where somebody is, I don't know, perhaps did not give 24 hours notice as they're supposed to for a cancellation, but they have a legitimate reason and they have documentation, which would be part of our rules, that would be, no fee would be assessed. There have been circumstances where somebody has said, and they're not somebody who habitually does this, has said that their child has been sick, but they were not sick enough to actually take them to the doctor and to pay the copay. And the amount that they would pay us would be the same as the copay, and there have been times that we have just not. So then not. No.
You referenced in your report to Dean being observed playing with a remote controlled car. Is that provided by Donna's house?
No,
Do you know where the remote controlled car came from?
I believe it came from the mother.
Is that in compliance with the rules to bring a remote controlled
Yes,
car?
many people bring toys. The issue is that the toys are not supposed to go home with the child unless they've been left at security. But many, many people bring toys to play with, yes. We have parents that bring an entire suitcase full and they just rotate toys throughout it and they bring a suitcase at a time.
You noted in the second paragraph of your report that on one occasion Dean bumped his head on a table and then tripped on the carpet on another occasion. Did Mr. Giles express concerns about that as well?
He expressed concerns because he said he was told that the child was wrestling and that his ear was bleeding. There was no notation of wrestling in there, but kids do get bumps and bruises. It does happen.
And that's all I have.
Just very briefly, ma'am, on the comment about this picture, are you aware that my client actually gave the picture to staff member without the child being aware?
I'm not sure if I'm aware of that.
Okay, hold
We had
on.
several conversations about it with staff.
Okay, I'm gonna just pause you there. And so you're not aware that she actually gave the picture to the staff and then your staff member actually took the picture and then apparently gave it to the child, but my client asked permission, correct?
Yeah, that she did ask
Yes,
permission.
and
I know that she showed it to the staff. I don't know whether she actually gave it to them, but she showed it to the staff,
Well-
yes, that I was told.
Okay, so do your reports or notes reflect that the picture was actually given to the staff member and then the staff member, after my client left, wound up giving that picture to the child? Are you aware of that?
I believe that is how it went down, yes.
Okay, so that incident,
It shows that Ms. Justice was trying to follow the rules
okay,
around
Was
that
she-
particular incident, yes.
so not trying, she did follow.
She did, yeah.
Okay, and if the staff member gave the child the picture without getting consent from the father,
That
that's
should
something-
not have happened,
But that's not anything my client did, correct?
no.
Okay. And so the suggestion by the plaintiff's counsel that maybe this wasn't quote slipped into the pocket, that's not accurate. It was actually given to the child by the staff member after my client asked permission.
Yes, yes.
No further questions at this time.
Just one info at that. Do you have personal knowledge whether she gave the picture to a staff member?
I was not present.
Nothing further.
Thank you. You're released. Thank you very much.
Thank you. It was very helpful. Thank you.
Just procedurally, Your Honor, we'll be able to,
1 second.
I'm sorry.
I've already put it on the record. 1 second. Let the witness leave and we're gonna address some housekeeping matters. You'll make those files available, Ms. Parlin?
Ma'am?
Ms.
Ma'am.
Parlin? Ms. Parlin? You'll make those files available, those notes?
I'm sorry,
I don't know when staff are going to come. When the attorneys are going to come, will you make those notes available?
Yeah, and I have everything here. If anybody wants to come to the office, so.
Okay, all right,
I will
thank
be
you
there.
so much. All right, bye-bye. All right, housekeeping matters. The witness is subject to being recalled during the break. Counsel can go. Frank, she can't get out. She needs to have some help, please. Counsel need to go during the break to review the notes if they want to review the notes. There are proposed exhibits by the plaintiff. Defendant, have you reviewed them? Do you have any stipulations as to any of the exhibits to save time in having them admitted?
We are, object to.
Just give me the ones that you're stipulating into evidence,
Yeah,
please.
sure. Court's indulgence, we would be okay with the medical records for Dad.
Give me the numbers,
I'm
please.
sorry,
Go 1,
Your
2,
Honor.
3, 4, 5. Start with
Yes,
number
we're not-
1.
Yes, we're not agreeing to exhibit 1.
Give me the ones that you are agreeing to and designate them by their designated number, please.
Yes, exhibit 7 we will agree to.
Admitted.
I apologize also, exhibit 5 and 6 and 4. So 4, 5, 6, and 7.
Are admitted by stipulation.
And we'll object to the rest.
Okay, very good. Do counsel wish to give opening statements?
Just briefly, Your Honor. Court's familiar with the facts of the case. The issue before the court today is the custody of the child and the issues such as visitation, child support, and the like. I believe the evidence will show that Mom has a history of instability in her personal matters as well as her care for the child, and go into much greater detail in that during the presentation of the case. Mom has not shown an ability to follow orders of the court or rules, and one of the reasons that Ms. Carlin is there as a witness is because Mom hasn't followed the rules of Donna's house. And when we look at which parent is more likely to foster a relationship with the other parent, Mom withheld this child from Dad for over 129 days. And only through this court issuing a pickup order was this child allowed to see his father. We believe the evidence will show that Mom essentially nominated Dad to be this child's custodial parent when she left the residence they shared, taking her older son, Coda, and saying to James, "You take your child, I'll take mine." Thereafter, she exercised very little contact with the child. She requested little contact. Dad acquiesced in the contact that she requested, and then she set him up on March 28th, feigning an interest in wanting to discuss the child, but instead making false allegations to the police against him, which were designed in conjunction with the efforts of her father to keep this child from Dad. We will get into substantial concerns about Miss Justice's father and his influence on the child. The evidence will show that Dad not only had been hands-on and primary caretaker for this child for his entire life, but also has been substantial in the raising of her older son, Coda, who previously she has acknowledged to the court that she entrusted Dean and Coda into Dad's care during a time when she was working and Dad was not. And Dad, as the evidence will make abundantly clear, is a very good father. He takes steps to ensure that Coda is safe. He has family support through his parents that all provide for Coda's needs in every respect. That the evidence will show that Mom has concerns regarding alcohol use, and that has impaired her ability to properly care for the child. That she essentially has chosen to pursue a party life rather than the life of a responsible mother. We believe that the evidence will show that Mom has actually neglected this child in the past to the point that medical involvement had to be sought. And when all of the factors that this court has to consider in determining what's best for this child are weighed, that the evidence will show that Dad should be the primary physical custodian. As far as legal custody, you will hear a number of very poor decisions that Mom has made with concern to the child, which frankly weigh against her having any decision-making authority for the child. Dad's going to request at the conclusion of these proceedings that there be a modified legal custody. Dad does not object to Mom having access to medical school records and such, but he does not believe she's capable of making good decisions concerning the child, so he could ask for sole custody as to decision-making. Visitation, again, I think the evidence will show Mom needs to kind of show that she can appreciate Dad's role in this bringing up of Dean, and that so far she hasn't done that. She's even gone so far after this court ruled against her on custody on a temporary basis to then raise a paternity issue, an issue that is entirely without merit. Child has Dad's name. Child's father is listed on birth certificate. Is the plaintiff. Dad acknowledged his paternity, clearly acknowledgement of paternity. These parties, before they separated, held out Dad as father. And he is biological father. We are quite confident of that. And Mom has raised no facts that would cast that in doubt. She's made arguments like, well, the child has blonde hair. We will show evidence that Dad has many similarities in appearance to Dean. And when he was at a similar age, his hair was blonde too. Again, we think raising this issue as kind of a second Hail Mary is another of the bad decisions he's made. But Dad is this child's biological parent. As far as child support, when Mom left in that July-August 2017 time period, provided no support for Dean. Dad cared for the child and provided for him up until Mom conspired to take away the child from him at the end of March 28th. Dad is had to incur attorney's fees in pursuing this action, which unfortunately have been caused by mom's improper actions.
Yes, just very briefly, all right. This is a young child. He is going to be 4 years old. He needs both parents in his life. I want to just address this issue of paternity. As we've made clear in all the filings that I've done, that this is not done to inhibit the visitation of Mr. Giles with the child. It's only to get clarification because we're here on all these issues. My client did have these concerns and will address that through the evidence. Again, I just want to make clear, it's not being done to say, oh, if you're not the dad, you can't have any visitation. She understands the child obviously has a relationship with him, but she was asking that because it could arguably be deemed waived. We don't know what this other father may do, but it was something that was always in the back of her mind. She wasn't 100% sure, and she wanted to confirm it. Again, it's not being done to disturb the visitation. We simply wanted to get to the bottom of it, and the child ultimately would have a right to know in case something came up. But I just want to make abundantly clear that it's not to be done to disturb the visitation. That's apparently how they're taking it, but that's not why my client asked for it to be done. Again, this is a very young child. He does need both parents. He needs both families. As I'll go through the factors in closing, Your Honor, but one of the factors is, can a child have a connection with a sibling? My client has another child. He's how old? 6 years old, so they're close in age. My client has full custody over that child. The father of that child apparently abandoned the child. These children have a very close relationship. My client's older son is in therapy now because he's having outbursts and is kind of struggling with missing his brother. He asked about the brother and things to that effect. As we put out in the brief, Your Honor, we're asking for joint custody, joint legal and joint physical. In their complaint, they noted that my client could have joint legal custody, and now they're changing that without apparently amending their complaint, and now adding in, now we want sole legal, but she can have access to records. Again, if she was such a danger to the child leading up to the complaint, why did they put she should have joint legal? So I think with Birch and C, after all this is done, at a minimum, she should have full joint legal custodial rights. And as far as custodial rights, we've asked for joint legal custody. The parties previously were following basically a schedule where she would drop the child off at James' mother's house on Friday evening. The child would then be dropped off at Felicia's mother's house on Saturday. And then from Sunday afternoon through Wednesday afternoon, James would have visitation and my client would have the other visitation. That's kind of how they followed that up until this March 2018 date when Mr. Giles was arrested for having a gun and apparently being under the influence of prescription medications. We know now apparently he's got prescriptions for the medication, but he did go to the home apparently with a firearm, and that's where everything changed for Mr. Giles, where then it became, now I'm going to basically try to punish you. Or again, he's asserting his rights, he's got every right to do that, but now it's casting my client as somebody who's totally unable to care for the child when they had this arrangement where they were co-parenting. It's very unfortunate that Mr. Giles has now taken this position that my client is not a good mother to the child. We know about the stuff related to the court order. Obviously, that's been addressed. My client is, as much as anyone I have ever seen, is totally on track with this court's orders, totally understands now you cannot question a court order, even if we know there was issues, obviously, leading up to when she got the order, putting all that aside, going forward, can she follow the orders? the answer is yes. You've heard the testimony now from Donna's house, Miss Parlin. There were no concerns noted by the staff. Apparently there were, these allegations made by Mr. Giles, and then what does he do? He just totally cuts off the visitation, and that should be, I think, very telling, because it shows what's trying to happen now. He's trying to run with the order and now trying to stay with this idea that she's a danger, and some of his allegations are even totally belied by what happened there, apparently. We would also ask, in relation to the physical custody, that either a week on, week off type situation, or with indulgence, I think we were asking for through Thursday through Sunday for you to have visitation. So we think that's more than reasonable, Your Honor. Split this up, give them the opportunity to co-parent together. They can use talkingparents.com. I asked for previously a behavioral order, and child support could be set. I think if the court does a time spent analysis under deviation factors, my client, she is employed at a coffee shop, does not have substantial income. She is living with her boyfriend, who does help support her. He's supportive of the child, both children, and that Mr. Giles, he's not employed. Apparently, we'll find out when he expects to ever be employed again, but we would ask that child support probably be deviated for time spent on the joint custody, or at a minimum under the right v. Osborne. My client understands that. We would reserve the right, Your Honor, to address the rest of this argument, but we would ask that, again, this is a situation, unfortunately there were a lot of roadblocks or speed bumps leading up to this point, but I think that for the best interest of the child, which is the sole consideration, the child should have both parents. Again, I think we should, to clarify, should get the paternity test ordered. If the court's not inclined to do that at this stage, we understand that, but at a minimum today, there should be an order of joint custody. My client is in good health. She again, besides this issue with the court order, is totally able to follow court orders, and there's no reason why she shouldn't have joint custody. And again, the acts of dad now apparently attempting to just unilaterally cut off the visitation is telling, because it shows he doesn't even want the child to have a relationship with her, Your Honor.
Plaintiff's case in chief.
Our first witness will be Felicia Justice.
Can you please raise your right hand? You do solemnly swear the testimony you're about to give in this act should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated.
May I proceed, Your Honor?
Yes.
What is your full name?
Felicia Marie Justice.
Where do you reside at the present time?
What do you mean?
Where do you live?
851 Purple Sage Terrace.
Purple Sage
Terrace.
Terrace. And what city is that?
Henderson, Nevada 89015.
How long have you resided there?
3 months now.
So when did you move into that residence?
The end of August.
And September and October and part of November you lived there.
Yes, sir.
Where did you live before that?
315 West Atlantic Avenue, Henderson, Nevada 89015.
And whose address is that, or whose residence is that?
It was my father's, Rob Justice. I was renting the place from him. He lived in a different house at the time.
How long did you live at that West Atlantic address?
After I moved out of mine and James Giles' apartment in August of 2017, I moved out and moved into the 315 West Atlantic.
That date of separation, you say it was August of 2017. Do you know the date that you moved out?
No, sir, I don't.
You're presently employed?
Yes, sir.
And where do you work?
Magnum Roastery, coffee shop.
How long have you worked there?
Almost a year.
And what's your work schedule?
I work Monday through Thursdays from 11 to 5:30.
Do you know if you have, at the present time, any outstanding warrants?
No, sir.
You have in the past, though, correct?
Yes, sir.
And what times have you had warrants outstanding?
Objection relevant, Your Honor.
Relevant to stability, and she's gonna be about around the child. We don't want her to have warrants.
Overruled.
How many warrants have you had outstanding for yours?
From my knowledge, one, I had a warrant in Arizona, and I asked James Giles' mother to help me out with it.
So you had a warrant in Arizona, when was that?
Pregnant with my first son, Coda.
What was that warrant for?
Speeding ticket.
And did the warrant get issued because you failed to appear for that?
Yes, sir.
You've also had traffic citations here in Nevada that is on the warrant, isn't that true?
I'm not sure.
Again, this would object, Your Honor, if it's not a criminal conviction for a felony or a moral turpitude offense, so it would be inadmissible.
I think we haven't even got there yet.
I think it's being offered for best interest. Relevance is a very, very broad thing when it's best interest. So it shows stability or lack of stability, shows many, many things besides having a criminal record. It's not, I don't think it's being offered for that purpose. As he answered in the first objection regarding relevance, it's not being offered for proof of a criminal record. It's being offered for stability or lack thereof is what I'm hearing. And so your objection and your continued objections regarding relevance as to this topic will be overruled.
If you look at Exhibit 2 in the booklet before you.
All right.
Have you examined pages 5 through 8?
All right.
That refresh your memory that you've had traffic citations going to work here in the state of Nevada?
Yes.
And how many times, now that your memory's been refreshed, do you recall having matters going to warrant in Nevada?
One warrant.
And that related to a citation for driving without due care, failure to increased fees back in 2013, correct?
Yes.
And we warrant because you failed to appear for court.
Yes. But
And you were held in contempt of court in that action. Isn't that true?
yes.
And as you review these documents in Exhibit 2, they are accurate, aren't they?
I believe so.
Move for admission of Exhibit 2, Your Honor.
Just would object, Your Honor, these are not certified court records, there's no custodian affidavit.
They are off the Clark County Justice Court website, and she has acknowledged that they are accurate.
Just would object the counsel being a witness for the foundation of the document.
I wasn't the witness, she was.
So for the record, pages numbered 5 through 8 is a copy of a register of actions from the public website, Clark County Justice Court. And the court is admitting them. They were authenticated by the witness, and it also comes from a public website that is a government website. So they are self-authenticating as well.
Do you know how long the Arizona warrant was in place?
I'm not sure.
And were you aware of how long the Nevada warrant was in place?
Yes, but once when the warrant came into place, I went to Ticket Busters and paid $500 to take care of it.
My question was, how long was that warrant in place? Do you know?
I don't know. It was a while ago. I didn't have Dean. I wasn't pregnant with Dean.
Yeah, you had COVID, correct?
He was a baby.
And you were traveling around with COVID at times?
No, I didn't. When I first came back, I didn't have a job. I was living with my dad. I wasn't driving around.
You did not timely file an answer to the complaint that was served against you in this matter, did you?
During what complaint?
You were served with a complaint by James where he's seeking custody of Dean, correct?
For the July 13th.
The complaint that we're here on today, he sued you back in May, April this year, you recall that?
Yes.
And the summons that you received told you you had a certain time to file an answer in response to that complaint, correct?
Correct.
And you didn't do so, did you?
No, sir. I had it ready, just wasn't able to file it.
But you were able to file a motion for waiver of mediation, correct? You did that on your own.
Yes, through Donna's house.
Again, if you would answer my questions, please, and not add any additional commentary, you counsel give a chance. You filed a TPO application on your own behalf back in April in this matter, correct?
Yes.
And we approach the witness, show her an application for temporary protective order.
For what purpose, counsel?
Well, maybe I can do it without approaching her. And you filled this out in your own hand, correct?
Yes.
And one of the questions it asked on the application was the relationship between you and Mr. Giles, correct?
Yeah.
Objection on reading, Wax Foundation, and he's reading from a document that she didn't testify, she doesn't have a recollection about.
I could approach and show it to her.
Well, first ask her if she recalls filling that out, and ask her if she recalls what she put as their relationship, and
Do you recall?
see if she can remember.
Fair enough. And so you recall filling out this application for protective order, correct?
Yes.
And do you recall one of the questions asked about your relationship with the person against whom you were seeking protective order? recall that?
Yes.
And do you recall what you wrote?
That was a while ago.
Would it help
You wrote a while ago?
It was a while ago from.
It was a
memory.
while ago.
It
Okay, you
was a
need to
while
raise your
ago.
voice because you are being recorded.
Okay.
Would it help to have me show you what you wrote to refresh your memory?
Yes, that's fine.
And approach the witness here.
Yes, now you may. Thank you for doing that.
I appreciate that, Your Honor. Do you see box 1, it says relationship,
Yes.
and can you tell the court what you wrote in on that particular application?
That I'm his ex-girlfriend, mother of his child.
Okay. And when you say mother of his child, you're referring to Dean Giles, correct?
Yes, sir.
There's another box there. On it talks about children. Do you recall filling out that portion of the box or the application?
Yes.
And do you recall what you put in the question concerning children?
Dean River Giles and Code of Justice.
Did you indicate that you and Mr. Giles had children together?
Yes.
And that was a box you checked out saying, we have children together, correct?
Yes.
You completed the code class?
The what class?
The code class?
What's code class?
It's a class that is provided to help parents going through a separation learn how to assist the child.
No, sir.
You're not aware of it?
No, sir.
You had a relationship with Mr. Giles of some 5 to 6 years before you separated, is that correct?
4 years.
When did your relationship start?
After 6 months, my son was born. My son was born in September 16th, so January, February is around, I don't know, summer. I'm not too sure. It was back in 2012, I guess, almost 2013. And we were just dating. We weren't officially in a relationship.
All right, so you met Mr. Giles sometime in 2012, is that correct?
Yeah, the end of 2012.
And you mentioned you had a child, you referring to Dakota,
Yes.
and he was born in September of 2013? Or 2012?
No, September 16th of 2012. So it was around 2013 when I met Mr. James Giles.
And you initially started dating, correct?
Yep, we would go on some dates.
When did you two start to live together?
So the beginning of 2014, maybe?
Okay, so beginning of 2014 through August of 2017 would be the period that you two lived together?
Well, we lived for a couple of months together. We broke up. I moved out, and I was living with him and his mother. I went back to my dad's house. It was several months after that. I moved into a house on Major Street. We were still separated, and during that time, it had been of 2013. He was going back and forth from California and back, doing whatever he was doing.
I'm just asking you the times you lived together.
Well, that's what I'm telling you. The times that we were on and off. We were never, like, together at all the time. We would break up and we would get back together.
And during these times that you're living together, you entrusted James with Coda's care, isn't that true?
No.
No. You don't recall telling this court when we were here in May of 2018 that
No.
you had James watching both Coda and Dean while you went to work?
That's when he was older.
Well, my question didn't
I
put
don't,
any time frame.
I don't know when you were,
So how old was Coda when you entrusted his care to Mr. Giles?
not until he was 3.
And how old was Coda when you left in August of 2017?
5.
So for a period of about 2 years, Mr. Giles took care of Coda.
Yeah, he didn't have a job.
And when you left the apartment you shared with Mr. Giles in August of 2017, you took Coda with you.
Took both kids. I called the cops. I tried getting both kids out. He tried yanking the kid out of my hands. That went to CPS. There is a record of it.
Again, if you would answer my questions, please. When you left that residence at that time, Coda went with you, and Dean stayed with his father. Is that
No,
correct?
it's not correct.
Okay. So are you saying you took both children?
Yes.
And for how long did you have both children?
For a couple of hours, the police told me that I needed to return Dean
Okay, I'm not
Giles at
interested in
5.
what the police told you, but in a couple of hours, Dean was back in the care of his father, correct?
Yes, and that's when we worked out visitation.
And you said, upon leaving, you take care of your child and I'll take care of mine.
Not true.
And you did not see, or attempt to see Coda, or attempt to see Dean until September 11th, 2017.
Not
A
true.
little bit over a month later.
Not true.
Did you see Dean between August, when you left, and September 11th?
September 11th?
Yes.
Yes.
Okay. And what occasions did you see him?
During the times that I was able to, I was working a lot.
Where were you working at that time?
That time it was Starbucks.
What schedule did you have?
My schedule
That was
varied.
what? Varied from what to what?
I was on call in full time, so it was on most of the time. I don't know, Monday through Fridays, and I was on call on some weekends trying to make extra money.
So you were working rather than seeing Dean,
I
right?
had to.
And you went with the police on September 11th to Mr. Giles' residence in, is that correct?
Yes.
And you took Dean for the day and then returned him later that evening, 5 o'clock.
Your Honor, I would just object to the very leading nature of questions. I was kind of holding back, but these
It's an
questions.
adverse party.
Hold on.
Let him finish.
But I'm everything now is this correct, that correct? It's very leading, Your Honor. You just asked the court to limit that type of question.
She's an adverse party, Your Honor, I think I'm entitled to do that.
With that clarification, that generally is the rule. I would just ask I'd be allowed to do it, but go ahead.
I think it's.
I withdraw
Adverse
my-
party, hostile witness.
I do withdraw my objection to that, Your
All
Honor.
right, thank you.
So I think when we had the objection, I was asking about taking the police to Mr. Giles' residence on September 11th.
I didn't take the police. I called the police from the place.
And that was Mr. Giles' birthday, wasn't
Yes, I was trying to move my stuff out.
it? And you took Dean and returned him at 5 p.m. that day, right?
No, I believe I was there to move my stuff out.
So you didn't really care about seeing Dean at that time?
I was seeing Dean. Yes, of course, I've cared to see Dean throughout his whole life.
I don't understand the answer or the question.
I would say, Your Honor, it's also very argumentative.
I didn't understand it. The question was, You took him for the day, you returned him at 5 p.m., you brought him back. And that was James's birthday. She said, I'm trying to move my stuff out. I didn't see Dean, but I've always wanted to see him. I don't understand your answer. On September 11th, 2018, did you take your child from the residence of Mr. Giles?
No.
Okay, you did not.
I'm sorry, what was
September
the date?
11th, 2018, did you take the child from Mr. Giles' residence?
No.
So you didn't have visitation with him that day?
And, Your Honor, I'm just confused. 2018, I think the child was already in his exclusive custody.
So, and that's the reason that we need years.
Yeah.
We're assuming years because, and let me make this point of clarification. Always use the year, always use AM and PM. Okay? When you say 11 to 5, I have no idea what that is. This is a 24-hour town. So I have to infer, and I don't want to do that. So you need to be very specific. Okay? Are we
Okay.
talking about 2017?
We are talking about 2017.
Thank you. 2017. Did you see him that day?
Yes, I saw him that day.
Did you take him from the residence?
No.
Thank you. Go ahead, Mr. Anderson.
Had you been drinking that day?
No.
On November 20th, 2017, you called Mr. Giles and proposed that you be able to see Dean one time a week. Is that true?
No.
You asked to see the child for Thanksgiving in 2017, correct?
We discussed Thanksgiving.
Okay. And Mr. Giles allowed you to see Dean for Thanksgiving of 2017, correct?
Correct.
And you also discussed seeing Dean for Christmas of 2017.
No.
Is that true? There came a point in time that you were discussing visitation with Dean, and Mr. Giles asked that you agree that he not be in his father, Robbie Justice's, grandfather, Robbie Justice's care.
No, I was living in his house. How is that possible?
I did not hear your answer.
I said no, no,
You said something else and I did not hear
Sorry.
your answer.
no on the answer. I was living in my dad's house that I'm renting from. It's not possible. He's gonna be around the child's life.
Okay.
Okay.
No, I was living at my dad's house, something is what I heard. You need to keep your voice up. If I don't get your answer, it didn't happen. Okay? Raise your voice, answer one more time.
No, that's not possible. I am renting from my father's house, which is Rob Justice. He's gonna see his grandfather, Rob Justice.
Well, let me clarify that. You said you were renting, and you also said that Mr. Justice was living there, correct?
No, Rob Justice was not living there at the time.
You didn't testify that just 3 minutes ago?
I'm living in his house that I'm renting from. He wasn't in the household then.
Did you have a lease?
No, sir.
Has he ever lived with you while you were renting?
Yes.
When?
He moved in 4 months after I did. I moved in August, September, October, November. So the end of January he moved in.
Year, please.
Yes.
Year?
The 2018.
So this year,
Yeah, this year.
January of 2018,
Yes.
he moved in while you were renting.
Mhm.
Does he still live there?
Yes.
Thank you.
So Robbie Justice moved into your residence that you're renting in January 2018, and how long did he stay there?
He's still there.
Dean continued to live with his father from August of 2017 when you left up until March 27th of 2018, correct?
Yes.
Can you say that question one more time, Counsel?
Yes. Dean continued to live with his father from the time you separated in August of 2017 up until March 27, 2018.
Thank you.
And you shook your head, but you said yes
Yes,
before.
yes.
Now,
Are you changing topics?
I am.
Okay, I apologize for interrupting. We need a short break. We'll take a 10-minute break.
Okay.
Thank you.